Hey everyone, as in the smallest surprise in the universe, Beverage, Canone, as we lovingly call her on this channel, has filed a motion to dismiss, well, deny the motion to dismiss. She's filed an order to dismiss, to deny the motion to dismiss. Because the claim violations here do not rise to a level that would justify the most draconian sanction of dismissal, and because the defendant's constitutional right can be fully protected in the coming trial, her motion to dismiss is denied. So, finally, a short video. My blood pressure can stay down. Bev have weighed all the evidence. She had weighed all the arguments. And she has found no violations that cannot be cured in a second trial. Nice. YouTube doesn't allow ads until 8 minutes, so I'm just going to sing a song for you. Or, no, let's do something else while we're here. Let's jump to some points I chose to highlight doing this. Because if you're going to read it, and I suggest you should, again, I'm not a lawyer. Go check out some of the great lawyers who cover this, because maybe I'm totally wrong. But when I read stuff in this denial, I can't even scream anymore because it's so stupid. First, page 6, on October 5th, 2022, an order was given that every video, everything, including the metadata associated with the photographs and videos, must be preserved and turned over to the defense. Well, that's good, because if you have metadata, you can prove if anything was tampered with. Oh, by the way, then go to page 13, where Beverage Canone then says, there's nothing in Rule 14 that entitled the defendant to the metadata or log files underpinning surveillance footage in possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of such evidence is required. Bev, I know you've been on a Cape a few times, but just if no order has been given, what's that? That's your order. Exactly stating that every effing piece of metadata needs to be turned over. Did you write this yourself? Or did people write it and you then mushed it together in the end and just missed that on page 6 you are ordering the Commonwealth to keep every effing piece of evidence, including metadata, to turn over to the defense? And then on page 13 you say, yeah, it's not a Rule 14 violation, they didn't do it, because why should they? Because you effing ordered them to do it. No, calm down. It's not worth it. Don't waste your day. It's 7 in the morning. Everything's fine. Then we go to another thing that I find a little bit weird. And I can't figure out the timeline in this part, because we start out with Bukaki testifying on June 5th and 6th. And they are showing the inverted Sallyport video. The direct testimony did not alert the jury that the video was inverted on cross. However, defense counsel questioned Bukaki extensively on the inverted image. The CPD began a review of other video surveillance footage in an attempt to explain the inverted image, and responded to allegations that it had deliberately manipulated the recording as part of the process. Rafferty herself reviewed surveillance footage from cameras in the hallway and the parking lot at the CPD in the early mornings of January 29th, prior to O'Keefe being discovered in the snow. Bev, have you been at your own hearings? Who told you this is an accurate statement? And are you going to bring sanctions against Hank Brennan for? Because if you believe this, Hank Brennan lied to your open face when he claimed multiple times that no evidence exists because it's overwritten every 30 days. Oh, by the way, it doesn't matter because you're not ever going to sanction the lying Commonwealth. But this is impossible. According to Hank Brennan, the system, not only the Sallyport video that he was talking about, but the system overrides everything in 30 days. So they couldn't go back and review any video. Shouldn't you call Chief Rafferty in and find out, hey, where did you get all of that evidence that you reviewed? Because I was told by the prosecutor that it's overwritten. Nope. Bev takes everything the Commonwealth says at face value, and everything the defense says is just, well, they should have fought harder. Nothing to see here. Another little thing that just pops in your eyes when you're reading this. And then you have, this is not to say the Commonwealth had no duty to turn over the Sallyport interior back wall footage before the trial. The production during trial was undoubtedly late. However, the defendant received the video more than a month before it was submitted into evidence, and because she had advanced no argument as to what, if anything, her counsel would have done differently if the disclosure has come earlier, the defendant has not shown she was prejudiced as a result of the late disclosure. But Beverage, are you gonna sanction the Commonwealth? Remember 2 months ago when you got your little hissy fit? When you blew up on the defense because they didn't disclose in a timely manner that they paid Aka, what was it, $22,000? Are you going to sanction the Commonwealth for this? Are you going to yell at the prosecution team? Of course not. Trust the prosecution, hate the defense seem to be how you rule. And it's clearly showing in this dismissal as well. Then we go to withholding exculpatory statements by Jennifer McCabe. First, we have her story about how, in anticipation to her trial testimony, she met with Lally McLaughlin and Brian Tully, and they asked her why her cell phone would have been at Lang's house. And McCabe says, well, I was with Kerry Roberts, who was picking up her daughter, and I didn't speak with Lang while there. The Commonwealth did not turn over the substance of the conversation to the defense prior to McCabe taking the witness stand. Oh, remember when you yelled at the defense for not turning over evidence in time? What are you going to do about this one? Are you going to throw little lally-bally out the courtroom? No, of course not. It's another violation of discovery. The ones you yell at constantly with the defense, even though this is clearly something you could have asked her about, saying, so you had a meeting being informed that we had your records on the phone, that you were at Lang's house. Is that why you, for the first effing time in 2 years, mentioned you were sitting outside in a car for an hour? Because Kelly is a talker. And then you went inside, had a pee, and then you went out again. You never ever talked to Lang. Imagine saying that in front of the jury while you had that. Well, it's not. The jury wouldn't have found in any other way if any of this has come in. There is no need to believe anything would have been different in this case if the Commonwealth hadn't hidden evidence. The Commonwealth therefore should have provided McCabe's statement to the defense after meeting with her and certainly before testimony. However, the defense cannot reasonably claim she suffered any prejudice as a result of not having McCabe's statement. No, because she couldn't have told the jury that the Commonwealth, who they claim made a shitty investigation, also prepped the witnesses. Could not have changed any juror's mind at all. Why do you start your day making videos about this? It's so stupid. It's so stupid. Then we get to the jury dismissal of Juror A. First, there's a story about Juror A helping to boot Juror B, and then, just before closing arguments, a member of the MSP had contacted court security and said that he received information that a juror thought to be Juror A was at one of the local posts for the American Legion talking about the case, and that there may be a recording of her doing so. At roll call for the Dedham police on the morning of June 25th, a number of officers confirmed that they have heard similar things about the juror. So based on hearsay and rumors, they call the juror to the stand and ask her if she had been at the American Legion. And she says, I don't know. Did you talk about the case? I don't know. I was drinking. According to Miss Beverly Canone, that's enough to dismiss her. No evidence been brought. No evidence that recording exists. It's just a rumor, but multiple officers have heard the same story. So in Beverly Canone's mind, if a lie is told enough times, it becomes the truth. And you can boot a juror because of it. It's, again, it doesn't have anything to do with making sure that you have checked your T's, crossed your I's, done whatever. The juror A did not deny that this occurred, but rather stated she did not remember and that she was drinking. The court then heard arguments for counsel about the action was taken. In deciding to dismiss the juror, the court considered juror A's her answers to the question, about the incident, as well as the fact that there was a previous incident involving juror A during which she was not entirely forthcoming about her communication with other jurors about juror B. So she's a lying liar who drinks, and that's why she's out. For the foregoing reasons, the defense motion to dismiss for extraordinary government misconduct is denied. The defendant's alternative request for an evidentiary hearing on the matter is also denied. I'm not a lawyer. I am but a baker. And I just put in some highlights. But again, everything in this seems to be if the Commonwealth said it or if Bev believes it. And who cares? She's getting a new trial. Justice will be served during a new trial where Bev is going to be just as biased as she was in the first one. Even more so, it seems. I don't know. What I can see in this is future appeals galore. She never, ever once tried to tell you why the clear Brady violations and the chain of custody for a Brady violation, why it doesn't matter in this case. Brady clearly states that any effing agent who has knowledge about a piece of evidence is the entire Commonwealth. It doesn't matter if Lally knew or Lally didn't know. In the eyes of the law, Proctor is Lally. Not one single time does she tell you why she doesn't think Brady matters in this case. Not once. She even claims her own rulings don't give the defense the right to have the things she ruled on. I don't know what's wrong in Canton. I had to go with the Canton triangle. It just doesn't make sense what is going on in this case. And it's infuriating to see a woman is going to be railroaded through the system because Beverly Canone, I don't know if she just wants to get it done or she wants out of here. But go look at some of the lawyers who covered this. I'm sure they can find even more BS going on. The least she could have done, the least, is having an evidentiary hearing with Chief Rafferty. How did she find deleted videos? Because she shouldn't have been able to. Fanning, who, if any, gave you the information about Juror A, and then called that person to tell them how they knew a month before at the American Legion. This person was talking about this case, and you didn't bring it up till right before you were gonna go and put the jury in the verdict room, jury room, that they were going to find a verdict. Deliberation room, that's what I tried to say. I'm getting heated now. And more than anything, how the hell has Bev put herself up as the jury in this case? The things she rules on that had no influence on the case if a jury heard it, is not for her to determine. That should be heard by a jury. Well, they do it at the second trial. Yeah, but do we need a second trial if your lazy ass didn't kick it out before the first trial? Again, I'm not a lawyer. I'm just a yelling Danish guy. But this is another infuriating part of the Karen Read saga. And sadly, nothing will happen. Beverly Canone will do as she always do, prepare for an appeal, because, hey, she can just appeal all my shitty decisions.